The second argument this morning is case number 29120, State of Ohio versus Enrique Green. The State of Ohio has waived argument in this matter. Representing Mr. Green is Attorney Lowry. He'll have 15 minutes to present his argument. We've read the briefs and are ready to proceed if you are Attorney Lowry.
I am.
All right.
Initially, Judge, I understand if the other side doesn't show up, I win. That's not true.
I think that
That's not the way it works.
That's
Not the way it works. Okay, well,
We'll hear from you though.
Yeah. If you read the briefs, I went back and reread my brief yesterday and today, as well as the reply brief, or the response and the reply brief. And I think, aside from not finding many typos, which I normally do when I reread stuff, that the brief sets forth the salient arguments in this case. But notwithstanding that fact, just as a little bit of an aside, I did not represent, obviously, the appellant in the underlying case. He was represented by other counsel. They waived the jury trial the morning of the trial and proceeded to try the case to Judge Rollins to the bench. Ultimately, she made a finding of guilty with respect to the felonious assault, and Mr. Green was sentenced to prison, I think for 4 years, for a period of 4 years. I was engaged to file the appeal. I've set forth several assignments of error. Some of them are obviously the same one, Joyce, the manifest weight, sufficiency of the evidence. But there's some other assignments of error, and in terms of sufficiency and manifest weight, I'd like to talk about some of the other ones because they're a little more unusual, and they relate to the sufficiency and the weight of the evidence argument. But notwithstanding that, there are some specific issues in this case that I think are interesting and a little bit out of the unusual. The one issue I have brought here is a claim for ineffective assistance under Strickland. I'm very mindful that that's a difficult task under federal and state law because I have to show that deficient performance as well as prejudice. But I think in this case, if you really take a look at a few things that I'm going to touch on, I believe that you can infer that this case is, and the fact that I had to issue or argue so many things on a plain error basis indicates that there were numerous, in my opinion, numerous issues in this case that should have been objected to that weren't, and so therefore I have to assert a plain error argument. And in the time I've been practicing law, I always seem to see somewhat of a corresponding notion between the concept of having to argue plain error and the issue of ineffective assistance. But first of all, I'd like to talk about the issue of expert witness in this case. The state called as an expert witness, even though in their brief they claimed that he was a lay witness, an officer to testify about certain things in the case. Notwithstanding the fact they called him as a lay witness, it's clear that the records suggest that they tried to qualify him as an expert witness. But what's even more interesting is that, once again, in their reply brief, they say that he wasn't an expert, but Judge Rollins considered him to be an expert, and in fact, in the transcript, she specifically alludes to the fact that he was qualified as an expert, or he was attempted to be qualified expert, when admitting evidence during the course of the case. So the state, while arguing that he was a lay witness, it's clear the court didn't perceive him to be anything other than an expert witness. And I had that, of course, you get going here, and then that was in the transcript at page 242. There's a conversation back and forth with the court, where the court, clearly indicates that the testimony was based on training experience as an accident reconstructionist. The problem then becomes, when qualifying Officer Gary, all he testified about is that he knows how to basically analyze skid data to determine the speed of a motor vehicle at the time of an accident. He doesn't testify anything about, ballistics knowledge, anything about, structural integrity of cars, anything about, wounds, trajectory, and yet he ultimately renders an opinion about all sorts of things that are outside of the ambit of a traffic reconstructionist, which is what he is, basically. You know, he testifies about how a bullet would traverse a shoulder. He testifies about the structural integrity of a pillar, where Mr. Green's car was struck by Mr. Jackson when he drove away, and the impact and the effect that it would have on the pillar of the car. He testifies about how glass would shatter from a bullet wound. He testifies about all sorts of things that clearly weren't within the ambit of any expert he has. So one of the things I do in my brief is I argue that he wasn't an expert under the requisite rules, 702, 705. He shouldn't be allowed to testify. If you take that testimony away, that's a large component of the sufficiency and or weight argument that the state relied upon. Because the judge in her questioning, you know, she alludes to this pile of glass. She alludes to, you know, all these things that Gary testified without objection. There was not even any cross-examination. I mean, counsel didn't say, you know, Mr. Gary, tell me about your experience with the structural integrity of cars, and tell me about your ballistics experts, about how bullets travel through tissue and how a bullet would react. All of those things, because one of the components was he made a claim that, oh, well, you know, the glass is consistent with the way the bullet would have traveled through his shoulder, which is consistent with where the glass splattered. All of those things, in my opinion, were inadmissible, and they shouldn't have come into the case in any manner whatsoever. And that was a huge component of this case.
When the court made that comment that you referred to, was he testifying about subject matter that might have been within the common knowledge of a police officer in their common experiences?
If you read the transcript, no. The comments that he made weren't, within the ambit of what an officer would know or what a layperson would know. They proffered him as, basically, and the state admits that they proffered him as a lay witness. You know, the specific things that he testified to would not be within the ambit of what a lay person could testify or what an expert could testify, in my opinion, if you read the transcript. I think it was a glaring error. I think there, you know, and that kind of transitions into the fact that if he's an expert, the counsel should have been provided with the requisite disclosure. There's no written report. A written report wasn't proffered at trial. A written report wasn't a reference at trial. He didn't allude to a written report. There was no written report presented whatsoever. This was all just testimony that should have been presented in the form of some sort of a disclosure as an expert witness, so that counsel and or the defendant had an opportunity to, if they wanted to retain their own expert, or to be prepared to testify or to cross-examine the so-called expert on his qualifications and or his ultimate opinions. I think that's a glaring error, but I guess the most glaring thing in this, and perhaps it seems silly, but I think that it really is the key. And families here today, and I explained to them that, or I suggested to her that one of the things that I try to do, and I've always tried to do, is when you try a case, you always try to have a story, or you always try to have some sort of a focal point. And in this case, without a doubt, the focal point of this case, and what should have really been stressed, and the fact that it wasn't, and that there was no cross-examination, I would have beat this point. And you can say it's trial strategy like the state, but there's no reason why trial strategy would have precluded counsel from arguing strenuously this issue of the bricks. Okay, and you probably saw these bricks. There are pictures of these bricks. Okay, State's Exhibit 1. And I invite you, and I don't know if the evidence comes over here, or if you go, I don't know how that works. But I would ask you to tell them to bring these bricks over that are State's Exhibit number 1. They aren't bricks. They're chunks of concrete, okay? And the one chunk must weigh 20 to 30 pounds. I mean, it's huge. These are not bricks. These are chunks of concrete. Now, follow, and if you take a look at the one that I guess is the most interesting, there's striations in them, okay, which seem to suggest they came from a construction zone, or it's just not a chunk of concrete. You look at it, and the first thing you say is, I wonder where this came from. But what's more interesting about them is that the state argues that the bricks aren't relative, because one of the things I argue that the reason why they're so relevant, it goes to state of mind, okay? Now, during this altercation, Mr. Jackson admits that he first showed Green a brick and threatened to bust his head or something like that, okay? The woman that Green is with, who is Jackson's old, they have children together, she specifically says in her testimony that she saw Jackson standing outside of Green's car with this brick. She specifically says that. So I've got a third party that places him outside of this car with this brick. He's admitting that there's a tussle. He admits that he said that he was gonna bust him up with this brick. The bricks. The bricks are supposedly in his back seat, Jackson's back seat. Supposedly, he picked them out of the street 3 to 4 days beforehand and put them in his back seat because he was worried about other cars hitting these bricks. Okay? If you don't think that's hard to believe, I must be the only one in this room to believe that someone gets out of their car, picks up 2 large bricks off the street, worried about other cars that are traveling, and puts them in their back seat of their car and carries them around for 2 to 3 days. If the truth be told, Mr. Jackson got those that morning, and he went over there with these bricks because he knew he was mad. He knew someone was over there that was probably in bed with his ex-girlfriend, ex-wife, or whatever, and he was upset. And he was upset because we know that because he had been texting and calling and burning up Miss Jameson's phone to find out when he could come over to pick up the kids. Could he come over at 3 o'clock in the morning after he had been drinking in a bar, okay, and knocking at the door, pounding at the back door, but yet the state in their brief says, well, the bricks aren't relevant because it doesn't go to his state of mind. You got to be kidding me. This guy has these bricks that he supposes he's been driving around for 2 or 3 days, but the most important and the most compelling thing about him is look at Exhibit 31, okay? Exhibit 31 is a picture taken of Mr. Green's SUV at the hospital. Mr. Green drives to the hospital. He pulls up. He's got a gunshot wound. There's a good photo of the gunshot wound. It goes in his, he got lucky. It went in the front and out the back. Take a look at it. It's horrific. Notwithstanding the fact he's got this open gunshot wound that's bleeding and obviously very painful, he testifies that he took the bricks and threw them into the back of the car. Okay? Take a look at Exhibit 31. It's obvious that what Mr. Green did really was when he got to the hospital, he went around, he took the bricks, and he placed them in the rear of his car. And you know why he did that? He did that because he knew he did something wrong. And he knew that ultimately those bricks were going to be an essential element of what was happening in this thing. And counsel never inquired about, tell me, Mr. Green, how that brick got in the back of your car. Did you get out? Did you walk around the side of the car? Did you pick it up? Which arm did you pick it up with? Why would you do that? Why did you feel it was so important for you to remove bricks from the front seat of your car into the back seat of your car if the bricks didn't have anything to do with this case and they weren't relevant?
You're saying Mr. Green, you mean Mr. Jackson?
Mr. Jackson, I'm sorry. Why did you do all those things, Mr. Jackson? You've got a gunshot wound in your shoulder, and you're telling me that the most important thing at the hospital is not to get in and get care, it's to move a brick from my driver's seat into the back of my SUV, go back, open the SUV, and place this brick. I'm telling you, this thing is 20 to 30 pounds. It is so unbelievable, and council never, ever, ever questioned him on any of that. And at the end of the day, this whole thing with the brick, you take a look at that, it transitions into a lot of these other arguments I've made about what should or shouldn't have been done. I see my time is up. It's amazing how fast 15 minutes go. I thank you for your time.
All right, thank you, Attorney Lowry, for your argument this morning. The court will take the matter under advisement, issue a decision in due course. And of course, certain courts will mail you a copy of that decision on the day it's released. You can also check for the decision on the Supreme Court of Ohio's website. Thank you again for your argument.
Thank you.